Very warm greetings. This is my CIA1 of Business Law case description. This project is submitted to Sachirag Ashwin Bhai and it is submitted by me, that is Naveen Kaur. In the following slides, we are going to discuss about two law cases that I have chosen. First is LALMAN Shukla versus Gauri Dutt case, and the second is CERS Ahmedabad versus Railways. So the case one is Lalman Shukla versus Gauri Dutt case. So let's study who were the main characters of this case. So moving on with what actually happened. So in this case, defendant Gauri Dutt's nephew was absconded and was nowhere to be found. After the defendant became aware of the same, Dutt had sent all the servants in search of the missing nephew. Now the plaintiff Lalman Shukla was one of the servants who had gone out in search of the nephew, and he eventually found him and brought him back. Now, when Lalman Shukla had left the house to leave for Haridwar from Kanpur, he was handed some money for his railway fare and other expenses. As soon as Lalman Shukla had left the house, defendant announced a reward of rupees 501 for whosoever found Dutt's nephew. The point to be noted is that Shukla had no idea that such an announcement was made. The plaintiff found the missing nephew and brought him back to his home in Kanpur. 6 months after the said incident occurred, Dutt sacked the plaintiff, and after that he claimed the money from the defendant and the latter denied to pay the said remuneration. As a result, the plaintiff Lalman Shukla filed a case against Gauri Dutt, his master, for not rewarding him as he was entitled to. This case was filed by Lalman Shukla in the year 1913 in Allahabad High Court that was presided over by Justice Banerjee. So there were three major concerns: whether Lalman Shukla was entitled to get the reward from Gauri Dutt for tracing the missing boy or not, whether there was a valid acceptance of the offer made by the plaintiff or not, whether there exists a contract or whether the situation amounts to a contract between the two. So, arguments that were put on behalf of the plaintiff, Lalman Shukla. He strongly affirmed that the very performance of him finding the missing boy was sufficient enough for him to be entitled to the reward. Since, according to Gauri Dutt's condition, whosoever found the lost boy and brought him back would get the reward. Therefore, as per the condition of the defendant, the plaintiff had traced the boy and brought him back. He also stated that it is not important to have prior knowledge about the reward, especially under this circumstance. He also emphasized the fact that Section 8 of the Indian Contract Act 1872 states that the performance of the act or the acceptance of any consideration or of a proposal is an acceptance of the proposal. So, moving on further. So now, what were the arguments put on behalf of the respondent, that is, Gauri Dutt? She asserted and strongly argued that Lalman Shukla was not aware of the offer and had no knowledge about it before finding her nephew. So, an offer without the knowledge of the offeree or promise cannot be accepted, and also there was no such possibility for the plaintiff to accept the offer without even knowing about it. So, what were the provisions of law applied to this case? According to Section 2, subsection A of ICA 1872, when one person signifies to another his willingness to do or to abstain from doing anything with the view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Further, under Section 2, subsection B, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So, the defendant contended that assent was essential to create a contract between both the parties. This means that before accepting the offer, the offeree must have complete knowledge about the facts to give assent or approval. But in this particular case, the plaintiff was completely unaware of the reward which was associated with it, and the plaintiff was merely doing his duty. Therefore, according to Section 2, subsection H of ICA 1872, since there was no acceptance, no agreement that can be enforceable by law, so according to Gauri Dutt, Lalman Shukla was not entitled to get the reward and hence he could not claim it. Moving on further, so what was the rationale behind this decision? So, in this case, it is derived that in order to enter into a contract, two very critical aspects should be considered. Number one, to have complete knowledge of the facts of the offer or proposal, and number two, acceptance of the offer. A person to whom the offer is made, the offeree, must accept the proposal. The communication regarding the offer is also very important as mentioned in Section 4 of Indian Contract Act. It states that communication can only be complete when it comes to the knowledge of the person to whom it is made. To convert a proposal into an agreement, both the knowledge and assent must be present. And here, in this instance, both were missing. So, as Lalman Shukla had no knowledge and hadn't given his approval or accepted the proposal, there did not exist a valid contract between the two. At the time when plaintiff was searching for the boy, his obligations and duties were as a servant. Therefore, plaintiff was not entitled to get the reward. So, let's see what the final judgment was. So, the judgment was in the said case, the petitioner's appeal against the respondent Gauri Dutt was dismissed by the court. After analyzing all the facts of the case, and the Honorable High Court held that for creating or entering into a valid contract, there has to be knowledge and assent to the offeree made by the proposer. Here the plaintiff did not know the reward before performing his act. He only came to know about it later, in which case there was no possibility of accepting the offer. Here there was no contract. Therefore, Lalman Shukla was not entitled to get or claim the reward. The judge reiterated that plaintiff was fulfilling his obligations as a servant of tracing the missing boy, which was a part of his duty. Therefore, the plaintiff's suit against the defendant was completely dismissed by the court. So, with this judgment, we come to the end of the first case, Lalman Shukla versus Gauri Dutt, where Gauri Dutt finally won the case. Now, moving ahead with the next case, CERS Ahmedabad versus Railways case. So, this is the next case, case 2. CERS is Consumer Education and Research Society, Ahmedabad versus the Railways. So, moving on with the case introduction, Mr. Manmohan Singh and his wife Kamlesh had bought a railway journey cum reservation ticket at Ahmedabad for travel from New Delhi to Kanpur Central by the Shatabdi Express on 2nd December 2001. However, the details on the ticket were illegible. As a result, they were forced to buy another ticket for journey. They applied for a refund for the earlier ticket, but as the forum noted, they had to suffer much for the purpose. In spite of the couples giving the Ahmedabad residential address for sending the refund, the railway sent it to the Delhi address. So they approached CERS for help. And so further CERS filed complaint against the railways. It filed a complaint against the railways before the Consumer Dispute Redressal Forum, Ahmedabad City, under Section 2, Clause 1, Subclause G, and Section 2, Clause 1, Subclause O of the Consumer Protection Act 1986. CERS claimed that two senior citizens had to face mental harassment due to the deficiency in service by the railways. So now the railways asserted that Forum had no territorial jurisdiction after the cancellation of the ticket. The couple were no more consumers in the eyes of the law. The complaint was time barred, and the Railway Claim Tribunal was the proper forum to entertain the complaint about the refund. So the provisions of law applied in this case were Section 2, Clause 1, Subclause G in the Consumer Protection Act 1986. Deficiency means any fault, imperfection, shortcoming, or inadequacy in the quality, nature, and manner of performance which is required to be maintained by or under any law for the time being in force or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service. The second one, Section 2, Clause 1, Subclause O in the Consumer Protection Act 1986. Service means any service of any description which is made available to potential users and includes, but not limited to, the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, board or lodging or both, house construction, entertainment, amusement, or the purveying of news or other information, but does not include the rendering of any service free of charge or under a contract of personal service. Spurious goods and services mean such goods and services which are claimed to be genuine but are actually not so. So, the final decision. The forum, however, observed that the couple's difficulties amounted to the railway's deficiency in service and ordered it to pay rupees 2,000 to the couple for the mental agony suffered by them and rupees 3,000 as the cost. The forum did not decide on the amount of refund, which it said was to be exclusively dealt with by the Railway Claim Tribunal. As a result, CERS wins the case against the railways. So, with this, we come to the end of the presentation. I would like to express my gratitude to Sir Chirag for giving this golden opportunity to do this wonderful project on the various cases descriptions, and which helped me in doing a lot of research work, and I also came to know about so many new things. Thanks a lot, sir.